Hello everybody and welcome to the second in this two-part series on the consequences of Brexit for jurisdiction and enforcement of judgments. For those of you who joined us last time, welcome back. And for those of you who are joining us for the first time, the first session of this series, focusing particularly upon the changes to the rules on jurisdiction post-Brexit, is available on the Quadrant Chambers website and on our YouTube channel. Today, our panel, Simon Rainey QC, Rob Thomas QC, Andrew Leung and myself, Gemma Morgan, are going to cover two things. First, how one now goes about enforcing judgments between EU member states and the UK post-Brexit. And second, a case study, which will hopefully throw up many of the more difficult issues on jurisdiction and enforcement that we have been discussing in this series. Now, if you do have any questions today on enforcement of judgments or arising out of our case study, then please do write them in the Q&A function and we'll do our best to answer them during the course of today's session. And if you would prefer your name not to be read out, then please do post anonymously. Now, the ability to enforce a judgment is obviously a crucial matter to take into account when considering the pursuit or defence of any litigation, particularly where you are pursuing a defendant domiciled in an EU member state, which might have assets in multiple member states, or indeed acting for a defendant who is so domiciled. You need to know how readily amenable the defendant's European assets are to enforcement by a judgment given in the UK and vice versa. In this jurisdiction, I think we'd gotten used to the easy and straightforward scheme under the Brussels Lugano regime, where judgments were automatically recognised and enforced between the courts of member states, subject only to very limited exceptions. But the rules that we now need to grapple with in the European sphere are more complex, in that there is now a fourfold regime that must be considered. First, in respect of judgments where the proceedings were commenced prior to the 1st of January of this year, then the Brussels Lugano regime will continue to apply. Second, in respect of judgments entered into by a court designated as the chosen state by an exclusive choice of court agreement under the 2005 Hague Convention, then the rules of that convention will apply. Third, in respect of enforcement of judgments in certain European Union member states, and enforcement here of judgments from their courts, then the Foreign Judgments Reciprocal Enforcement Act 1933 or potentially the Administration of Justice Act 1920 will contain the relevant rules if there are bilateral treaties in place with particular member states. And fourth and finally, for judgments which fall into none of these categories, of which there will be many, I predict, then the rules of the common law here and domestic rules on enforcement in member states will apply, for which obviously local law advice will need to be taken. Now, when considering which regime one needs to turn to for enforcement of a commercial judgment within Europe, asking yourself the 5 questions which I've set out there on the slide is likely to be instructive and point you in the right direction of the likely applicable regime. So first, what was the date of commencement of proceedings which gave rise to the judgment? This is obviously relevant for the question of Brussels Lugano or not Brussels Lugano regime. Secondly, the courts of which state gave the judgment. Again, this is relevant for deciding whether you might be in Brussels, Lugano or Hague Convention territory, or indeed falling under the 1933 Foreign Judgments Act. Third, is there an exclusive choice of court agreement in favour of the courts of that state? Well, if there is, then you might be within the Hague Convention if the state chosen is a signatory. Fourth, if there is an exclusive choice of court agreement, when was that choice of court agreement entered into? Was it before the 1st of October 2015? And again, this is relevant to whether or not the Hague Convention can apply. And fifth and finally, what is the nature of the claim? And that is relevant because not all of the regimes enforce the same types of judgments. And so you need to check that you've got a judgment of the right type that is covered by the regime that you're seeking to use. Now, it's important to note that these regimes are not all mutually exclusive. So a bar to enforcement under one regime does not necessarily preclude the use of any other. So I'm going to look first at, and briefly at the Brussels Lugano regime, because as I've said, it will still be relevant for some time to come because it continues to apply to judgments arising out of proceedings commenced before the 31st of December 2020. Again, we're looking at dates quite a lot here, but it's important because the original Brussels regulation applies to any judgments given in proceedings in member states started before 10th of January 2015. And it is possible that judgments of that nature are still being enforced now. The Brussels Recast regulation applies to proceedings started after the 10th of January 2015 for EU member states. And the Lugano Convention applies where you're looking at judgments in Iceland, Norway and Switzerland. And the Brussels Lugano regime applies, of course, to both UK judgments being enforced within the EU or Lugano states and judgments from those countries being enforced here. And I think it's important to just remember that the rules apply regardless of the nationality of either the claimant or the defendant. So questions of domicile are not relevant to enforcement under the Brussels Lugano regime. So what does the regime require? Well, focusing on the Brussels Recast, because I think that's the one that comes up most often, in simple terms, if you have a judgment of a court given in a civil or commercial matter, then it will be enforced, unless the judgment debtor can show that one of the 5 limited grounds for refusal of enforcement in Article 45 is made out. And I've set those there out on the slide. So that's the point where we jump off into the unknown. And I'm going to hand over now to Simon, who's going to talk us through the Hague Convention regime.
Thanks very much indeed, Gemma, and good morning, ladies and gentlemen. Very nice for so many of you to come back, and good morning to the new faces. I think Gemma's absolutely right when she says the unknown world. What I'm going to talk about is the Hague Convention 2005, the convention that no one knew about, which I think will be the main replacement for Brussels Recast to the extent that it covers. So I'm going to be looking at recognition and enforcement of judgments under the Hague Convention 2005. For those of you who weren't here last week, and in case you missed it, let me give you a quick recap, which is necessary to understand the background to the Hague Convention. There are 3 threshold requirements for this convention, and so you need to have these very clearly in mind when you're considering it. First of all, it needs an exclusive choice of court agreement in writing, Article 3, and Gemma told us about that last week. A mandatory jurisdiction clause, we're going to get a question on it in the case study, won't include an asymmetric jurisdiction clause, is the current view. It needs an exclusive choice of court agreement which has been concluded after the entry of the convention into force for the state of the chosen court. And there's a spat, which might be quite an important spat, between the EU and the United Kingdom, as you might imagine, as to when we actually acceded to the Hague Convention. Do we accede when the EU acceded, or do we have to make our own accession, which we did anyway, and therefore we only acceded in January of this year? And thirdly, and something I will come back to, the proceedings and the judgment to which they give rise must relate to matters to which the convention applies. The convention is much less wide than Brussels, and that's going to be a problem for quite a few cases. So let me deal first of all with recognition and enforcement under Articles 8 and 9 of the conventions. And I stress, this is recognition and enforcement of UK judgments in the EU, so in a EU member state, you're taking your judgment to Austria or France or the Netherlands, or you've got a judgment in Germany or Belgium and you want to enforce it in the United Kingdom. The rules will be the same. While this globe makes it look as though the Hague Convention has a huge global reach, as you know, it doesn't. It's mostly the EU member states, Montenegro, Singapore, and 1 or 2 others. So the guiding principle is that there is an exclusive code comprised in Articles 8 and 9. The recognition and enforcement is dealt with by Article 8. And this is nice and terse, and it says that a judgment given by a court of a contracting state and designated an exclusive choice of court agreement, so you've got an exclusive choice of court agreement that says France or England, shall be recognised and enforced in other contracting states in accordance with this chapter. So far, so good. Recognition and enforcement may be refused only on the grounds specified in the convention. So that's ring fencing the judgment and protecting it and making its recognition and enforcement effective and giving certainty, because you will find the only grounds for not recognising and enforcing in the convention. And importantly, Article 8.2, there is no review of the merits of the judgment given by the court of origin. The court which is addressed is bound by the findings of fact unless the judgment was given by default. So default judgments, as we'll see, may have slight wrinkles, but if you've had a full contested case on the trial, on the merits, then the court will not investigate whether the judge or judges were right or wrong. But some particular notes, some points to note about Article 8. You have to bear in mind the nature of the original judgment sought to be enforced. So you have to have a judgment which is actually enforceable in the state of origin and has full effect in that state. Secondly, if your judgment is under appeal, or time for appealing has not yet expired but no appeal has yet been lodged, you can still bring it along for recognition and enforcement, and it may still be recognised and enforced. But the court may, it has a discretion, to postpone or refuse recognition and enforcement until the appeal process has completed. And then you can come back and try again. And then there's a strange provision about cases transferred by the chosen national court, which may matter if you've picked a particular court. For example, if you say the Tribunal de Commerce de Paris, and the Tribunal de Commerce de Paris says, well, you can't bring it here, bring it somewhere else in France, then that is something which may be relevant to enforcement. So that's Article 8. Article 9, as I've said, defines the grounds for non-recognition. And the grounds really fall, I think, into two categories. First of all, matters affecting the particular judgment, Articles 9a to 9d. So the agreement, the jurisdiction agreement is null and void, unless the court of origin has said that it isn't. Lack of capacity. Capacity is judged by the place where you're trying to enforce the judgment, not the place where you got the judgment. Insufficient notice to the defendant of the original proceedings, so he didn't really have a proper chance to defend himself or herself. Notice of the proceedings was in a way which was incompatible with fundamental principles of the requested state. So looking at the rules for service and notice, they're very, very tight compared to the views of the state where you're trying to enforce it. And some aspect of fraud in connection with the procedure. That's one group of grounds for non-recognition. The other group of grounds for non-recognition really depend upon how the requested state views the judgment. So we've got a public policy exception, including fundamental principles of procedural fairness. Interestingly, where the judgment is inconsistent with the judgment given in the state where you're trying to enforce in a dispute between the same parties, so somebody's already got a judgment, or the judgment is inconsistent with an earlier judgment given in another state between the same parties on the same course of action. So that's dealing with, as it were, the conflicts between competing judgments. Can I ask you, ladies and gentlemen, to note importantly Article 10, because this is going to be a big area when you're seeking to enforce your judgment. As I've said, the Hague Convention is subject to a wide range of exclusions. Article 10 reflects that. Any preliminary rulings by the Court of Origin dealing with excluded matters are not recognised or enforceable. The main judgment will not be recognised or enforced if it is based on a ruling on a matter which is excluded under Article 2. And similarly, the main judgment will not be recognised or enforced if it is based on a ruling on a matter excluded by the requested state under Article 21. Now that brings me back to something I dealt with last week, and I'll deal with quite quickly. Just a recap on the exclusion and inclusions under Article 2. As I explained last week, the exceptions to the scope of application of the Hague Convention are much wider than they are under Brussels Recast. Under Brussels Recast, it was status issues, arbitration, social security. Here, as you see, tort claims, property claims, intellectual property right claims, and claims for personal injury all are excluded. And importantly, for those of us that practice in the commercial court, also excluded are claims relating to the carriage of passengers and goods by road, rail, air and sea, marine pollution, limitation of liability and things like that, but all other shipping matters, including marine insurance, shipbuilding, etc., are included. So you're going to need to work out what the subject matter is of your action. And importantly, Article 21 reservations in the country where you're seeking to enforce the judgment need to be borne in mind. The main reservation which has been made by all the EU member states relates to insurance. Under Article 17, insurance is in, but under Article 21, all EU member states, including the United Kingdom when it was one, have excluded various categories of insurance, and therefore you need to work through what type of insurance contract it is. Reinsurance, marine insurance are in, other types of insurance are largely out. So those are the rules under Article 8 and Article 9. And I want to turn briefly to the procedure for recognition and enforcement under the Hague Convention. This is not such an interesting part of the talk, if that is, even if the earlier part were interesting. I wanted to get a picture to give an impression of what it must be like in the Royal Courts of Justice in the service room, the white heat of technology. This was the only picture I could find of the Ritz room it used to be in the law courts. The necessary documentation is defined by Article 13, and I won't go through all of that. It's on the slide. You take along the copy of the judgment. You take along documents necessary to establish the judgment has effect, or where applicable is enforceable in the state of origin. And if you're dealing with default judgments, then you've got to satisfy the requirements showing that the judgment debtor was properly notified. Article 10 and Article 15 go together. Article 15 reflects the fact that Article 10 says you can't enforce a judgment which relates to excluded matters. So Article 15 says you can sever an application for recognition and enforcement to limit it to the matters which are properly included within the scope of the Convention. Unfortunately, procedure for recognition is now anybody's guess, because it depends on which state you're trying to enforce it. Under Article 14, here is a snapshot of various palais de justice and justice palates in various countries, Austria, France, Belgium, and so on. But you'll notice in Article 14, perhaps this is a pious hope, the court addressed shall act expeditiously. Well, we'll have to wait and see quite how expeditious it is and quite how much staff they put on to do it. Where the requested state is in the United Kingdom, then we go back to the Civil Jurisdiction and Judgments Act of 1982 and Section 4B. Each of the countries making up the United Kingdom, England and Wales, are treated as one, and Northern Ireland in the middle there, and Scotland on the right, will have their own regimes. For England and Wales, it's CPR 74. Section 4B of the 1982 Act, I've set out there on the slide. The most important thing to note about Section 4B is that it requires you to act without delay in recognising your judgment. So if you hang about, you may find the court is sniffy about enforcement and recognition. But most importantly, the person who wishes to oppose recognition and enforcement cannot do so on the application for registration. It has to apply separately. So registration goes through automatically, and then if you don't like the judgment and you want to try and set it aside on some of the Article 9 grounds, you come along afterwards. Thank you very much indeed. I'm going to stop there. I'm now going to hand over to Rob, who's going to be talking about statutes which a lot of us haven't had to look at for years. The Administration of Justice 1920, the Foreign Judgments Reciprocal Enforcement Act of 1933, and as Rob, I think, has subtitled this talk, this is the exciting stuff.
Thank you, Simon, and good afternoon from me. As Simon has just said, I have the pleasure of dealing with all the exciting stuff, just like last week. So if we can look at what the exciting stuff entails, it's the Administration of Justice Act 1920 and the Foreign Judgments Reciprocal Enforcement Act 1933. As Simon has said, these two acts are probably best remembered, if they're remembered at all, as one of those rather niche topics on the conflict of law papers that nobody really paid much attention to and probably didn't actually understand. But really important is to understand that they permit judgments from a number of foreign countries to be enforced after registration. And it's useful to understand in this context that the reason for these acts is that the common law does not and did not and does not enforce foreign judgments as judgments, but what it allows is for foreign judgments to pave the way for a judgment creditor to obtain a judgment in the English courts and then to enforce that judgment. So where a procedure under these two acts is available, there's no need to bring an action at common law. And it's fair to say that where the procedure under these acts is invoked, the court is in fact enforcing the foreign judgment itself. And for this reason, it's important to appreciate that whether you can do so is dependent on the legislation having identified and specified the countries and their court judgments. And it's only those judgments which may be registered for enforcement in accordance with the rules. That once judgment is registered, the foreign judgment takes effect for the purpose of execution and for the accrual of interest, as if it had been a judgment of the English court in which the judgment has been registered. So that's the important effect of registration. On the practical side, registration is available, and I guess will almost always be on without notice application. And of course, if it's to be challenged, an application will therefore have to be made to set aside the registration, and that's where any likely action is going to take place. Now, as an overview, before we look at some of the details, as may be obvious from their dates, the principles underpinning these acts owe a great deal to the common law rules in force. So turning briefly to have a look at the two acts separately, first of all, the 1920 Act. It applies to enforcement of certain judgments from the courts of many British overseas territories and Commonwealth jurisdictions. And whilst you might therefore think this isn't relevant to our Brexit chat, you need to think again, because amongst the countries falling within that elite band are Cyprus and Malta. So the Act does remain relevant in the post-Brexit era in relation to those two countries, and obviously any other overseas countries as well. Now, the heart of the Act is section 9. I put the key words up on the screen, but in essence, what it provides is that where a judgment has been obtained in a superior court of the relevant dominion, the judgment creditor may apply to the High Court within 12 months after the date of the judgment to have the judgment registered in the court. And on any such application, the court may, if in all the circumstances of the case they think it just and convenient, to allow the judgment to be registered. So points to note from that is it's only applicable to the superior courts of the relevant jurisdictions. There is a 12-month limit. And as you'll see from the words just and convenient, there is at least a discretionary element in the process. I would add, and it's probably important given the audience, to note that by section 12, a judgment in proceedings on an arbitration award is in principle capable of being registered under the 1920 Act as well. So far, so good. The Act continues in section 9 with a healthy list of reasons why judgments may not or should not be registered. And again, I've put it up on the screen, but as you'll see, it provides that there shall be no registration if the original court acted without jurisdiction, if the judgment debtor was neither carrying on business nor ordinary resident in that jurisdiction and hasn't voluntarily appeared. So that's quite a significant restriction. The third restriction is where the judgment debtor was not duly served. There is the fraud exception, unsurprisingly. And also, subparagraph E, you'll note that the procedure is not available where an appeal is pending or the relevant party intends to appeal against the judgment. And finally, of course, there is a public policy exception in subparagraph F. So as you'll see, in contrast to, for instance, the Brussels regime, there is plenty of scope to raise objections in the English court. And to that list, you can also add what might more broadly be described as breach of the rules of natural justice, which may not fall explicitly within the wording of subparagraph 2, but it's hard to see, certainly in my view, whether, that such a problem or judgment reached in breach of natural justice would be just and convenient to register. And as a footnote, the Human Rights Act, of course, would also apply here as well. So that's a whiz through the 1920 Act. If we turn our attention then to the slightly later 1933 Act, this again largely reflects the common law position and applies to the enforcement and to the recognition of judgments from countries with which a bilateral treaty is concluded and which, in accordance with the Act, has been enacted into domestic law. What that means practically is it will be necessary to look at the particular treaty which will appear in the provisions of a statutory instrument to see precisely which courts in which countries are covered by this Act. In principle, the Act covers judgments or orders given or made by a court in civil proceedings, or a judgment or order made by a court in any criminal proceedings for the payment of sums of money in respect of compensation or damages to an injured party. So it's broad in scope. And the provisions of the Act apply in the ordinary way, as I've just described, to judgment given in relation to an award in arbitration proceedings, which has become enforceable in the same manner as a judgment given by the court of the relevant jurisdiction. Now, unlike the 1920 Act, enforcement by registration is mandatory in the sense that if the conditions of the Act are met, proceedings under the common law are not permitted. So again, relevant to the Brexit scenario, question mark, to have a short drum roll, which countries are affected by the Act. There's a list on the screen, former European, currently European, but formerly falling within the Brussels regulation: Austria, Belgium, France, Germany, Italy, the Netherlands, and Norway. I should issue one short health warning. There are plenty of comments out there saying it's not at all clear whether the old treaties will apply. None of them explain why they say that, so not very helpful in that context. But those observations do seem to me to ignore the fact that the 1933 Act continued to apply even during the European era, where, for example, an arbitral award had become enforceable as a judgment in the relevant country. In other words, the scope of the Act is not coextensive with the Brussels regulations, and there is certainly, in my view, no reason to believe that they won't continue to apply. But I just flag up there may or may not be an issue in that context. Moving on, the 1933 Act gives you a generous 6 years to apply, unlike the 1920 Act. And similarly, it's not a defence to registration that the judgment is subject to appeal in the foreign court, although that might provide a ground for setting aside registration or staying proceedings on the application to set aside. And in any event, as the slide notes, if the judgment is not liable to execution under the law of the state in which it was given, it may not be registered in the first place. But an important, potentially important difference there between the 33 Act and the 1920 Act. Now, the key provision in the 1933 Act is Section 4. And again, I've set out and sought to highlight the key provisions there. It provides the registration of judgment shall be set aside in case the judgment is not a judgment to which this part of the Act applies or was registered in contravention of the Act. There's a similar carve out for the situation where the original court had no jurisdiction, where the judgment debtor did not receive notice of the proceedings, where the judgment's obtained by reason of fraud. And again, there's a public policy exception and a final exception where the rights under the judgment are not vested in the person by whom the application for registration is made. So as you'll see, reflective of the common law position and not entirely dissimilar from to the 1920 Act in its scope. And the same comments I made earlier about the 1920 Act and the failure of Natural Justice and Human Rights Act would apply equally to the 1933 Act. And then just to mention subparagraph B of section 4, it provides that the registration may also be set aside if the registering court is satisfied that the matter in dispute in the proceedings in the original court had previously to the date of judgment in the original court been the subject of a final and conclusive judgment by a court having jurisdiction in this matter. So there's another ground upon which registration may be set aside. So there we go. That's a whiz through the 1920 and 1933 Act. Just a final observation, which I think I've already made, but if enforcement of a foreign judgment may fall within the 33 Act or the Hague Convention, then the judgment creditor must use the statutory regime and cannot sue on common law. And on the topic of common law, I will now unshare my screen and hand over to Andrew, who is going to talk us through the position at common law.
Going to whiz through this fairly quickly because I suspect we're all rearing to crack on with the case study. And it so happens that rather conveniently, the position at common law can be summarized fairly swiftly. So as Rob pointed out, in terms of enforcement, as a matter of common law, only an English judgment is capable of being enforced in England. The foreign judgment merely provides the cause of action. And to enforce it, the claimant has to bring an action enforcing the obligation created by the foreign judgment. But for the foreign judgment to be enforceable as a debt, it must be for a fixed sum of money. The precursor to enforcement is, of course, recognition. Only a judgment capable of recognition may be enforced. So let's explore the requirements for a judgment to be recognized in England. First, it has to be the final and conclusive judgment of the foreign court. And that means a judgment that is not provisional or subject to review by that court. If the only way to contest the issues in the foreign jurisdiction is to appeal to a higher court, the judgment appealed from will still count as final and conclusive. And second, the court must have been competent to give judgment as a matter of English law. Now, whether the foreign court is competent will turn on whether the defendant was present in its jurisdiction or whether it submitted to that court's jurisdiction. Starting first with presence. The physical presence of the person to be sued, and quite obviously establishes the competence of the foreign court if that person is present in that court's jurisdiction. But what about corporations? As a matter of general principle, for a trading corporation to be regarded as present, there must be one of two things: either agents or employees of the corporation carrying on its business from a fixed place of business maintained by the corporation, or a representative of the corporation carrying on the business of the corporation, again, from a fixed place of business. Now, in relation to the representative, an important question will be whether he or she is able to enter into contracts on behalf of the corporation without needing to submit them as proposals for a decision to be taken by somebody else, elsewhere in the corporation. Submission is the other way of establishing a court's competence. Now, if a contract provides that a foreign court is to have jurisdiction to determine a dispute, that court is likely to be recognized as jurisdictionally competent, and that's the result which you would expect. It's also obvious that a claimant who submits to the jurisdiction of a court by making a claim and issuing a writ has submitted to that court's jurisdiction. And equally, a defendant who appears in the foreign court and contests the merits of the claim will have submitted. It's important to note that for these purposes, the fact that the foreign court concludes it has jurisdiction, and or that, for example, an English choice of court agreement is not binding, will not be conclusive from the English court's perspective. The question is whether, as a matter of English law, the defendant was either present in the foreign jurisdiction or submitted to the foreign court's jurisdiction. The English court will not recognize a judgment given in a foreign court, which has been brought, where the proceedings have been brought contrary to a binding choice of court agreement, unless the defendant waived the claimant's breach. For example, by counterclaiming in the proceedings or by otherwise submitting to the jurisdiction of the foreign court. And that is the result of Section 32 of the Civil Jurisdiction and Judgment Act, 1982, which is a slightly unwieldy piece of legislation. And what it does is it largely codifies the position at common law. Now, if a defendant establishes that foreign proceedings have been brought in breach of a choice of court agreement and the defendant didn't submit to the jurisdiction of the foreign court, judgment for the defendant will be recognized as conclusive against the claimant as a matter of English law, and the claimant will then be deprived of an unmeritorious argument that the foreign court had jurisdiction, because ex hypothesi, that argument will be based upon his own breach of the choice of court agreement. So I said my section is going to be brief, and I think it's time now for us to explore how these principles apply in practice. So without further ado, I'm going to stop sharing and return us to Gemma, who's going to outline a case study for us.
Thank you, Andrew. Well, that was hopefully the background that you'll need to be able to answer the questions in our case study. Unfortunately, because we're not in front of a in-person audience, we can't throw out questions and pick on people. But I will certainly try and pick on some of our panel to see what the answer is. So I will try and share the study now. So the synopsis that we're going to look at, and we'll mix it up a little bit as we go, it is a voyage charter party dated 1st of January 2020, a German owner and an Italian charterer, and it contains an English law and jurisdiction clause stating the English High Court will have jurisdiction to determine any dispute arising out of or in connection with this charter party. And the charter party does incorporate the Hague Visby rules. A dispute arises about damage to the cargo suffered during the voyage by reason of alleged unseaworthiness. The vessel also suffers damage during discharge due to an allision with what the owners say is an unsafe berth. So the cargo is delivered in Italy. The Italian charterer wants to claim damages, and the German for the damage to the cargo, and the German owner wants to claim damages for the damage to the vessel due to the breach of the safe port warranty. So, bearing in mind that background, let's try and work through some of the questions that arise out of that scenario. So let's start at the beginning. Let's say the Italian charterer commences proceedings in Italy now, June 2021. Can the German owner start proceedings here in England and immediately obtain an anti-suit injunction from this court to restrain those Italian proceedings? Given that I've thrown open the question, I might as well try and break it down a little bit. I think there are probably two questions to answer within that. Firstly, whether or not the English court has jurisdiction to hear the claim. But secondly, then, if it does, would it go on to grant an anti-suit injunction? Simon, why don't you kick us off with the question of jurisdiction?
Okay, I will. It's an interesting conundrum, this case study, because it throws up precisely the sort of issues we're all going to be grappling with. There are three possible bases based on the talks we've had this morning. The first possible basis is under Brussels I Recast. Well, that's not going to work because the proceedings were commenced post the completion date when we came out of the EU, so we can cross that off. So now we come to the Hague Convention. Well, the proceedings have been started at a date after Britain, the United Kingdom, acceded to the Hague Convention in January 2021, and so the Hague Convention is potentially in play. It's an international case, it's civil and commercial, so it looks as though it's within the Hague Convention. But remember, one of the exclusions which I identified for you, ladies and gentlemen, which is in Article 2, Paragraph 2, little g, which excludes actions and claims relating to the carriage of passengers and goods. Now, let's take the easy claim. The Charter is claiming damages for damage to goods and is suing under the Voyage Charter Party. That looks like a claim relating to the carriage of goods because it's the carriage of goods by sea. The Hague Convention doesn't, interestingly, say contracts for the carriage of passengers and goods. What it says is the carriage of passengers and goods. But you've got to read the provisions of the Hague Convention together with the explanatory report, which will, and has already, in one case, been regarded as significant by the English court in interpreting the convention because it's meant to be read with it. So Professors Hartley and Dogauchi, in their report, refer to the fact that the exclusion is dealing with contracts for the carriage of passengers and goods. And the reason they give for the exclusion, which is a very odd reason in my view, is that because there are international conventions regulating those contracts, Warsaw Convention for air, CMR Convention for road, Hague and Hague-Visby rules for sea, because there are international conventions regulating that type of carriage, the drafters of the Hague Convention didn't want any conflict. Very, very odd, because unlike the CMR Convention, Hague and Hague-Visby rules say absolutely nothing about jurisdiction. But anyway, that's what's been excluded. So I think, based on Article 2.2g and the explanatory report, the Charterer's claim would be a claim which is excluded. So that would not be within the Convention.
Well, but that brings up an interesting question, doesn't it? Because you say the Charterer's claim, but does it make a difference under the Hague Convention what the claim is in respect of? Because I can see that the claim in respect of damage to the cargo is clearly arising out of carriage of the cargo. But what about owner's unsafe port claim? I mean, is that really a matter of the carriage of passengers and goods? What do you think?
I think then you have to look at Article 2, Paragraph 3, which says that the proceedings are not excluded unless the matter is not the object of the proceedings. Now, a cargo claim is obviously the object of the proceedings. It doesn't matter whether the point is a contract of carriage or carriage of goods. The object of the proceedings is carriage of goods. It's caught by the explanatory notes. It's caught by Article 2, Paragraph 2g. But a claim by the owner for damage to his ship caused by a breach of a term in what might, for the charterer's perspective, be a contract of carriage, and for the owner's perspective, be a contract of carriage. Is that a claim whose object is the carriage of goods? I don't think it is. Remember that the explanatory notes say that all other shipping matters, apart from those specifically excluded, are included. And there's a very helpful account in the explanatory notes, which really do make very good reading, which says that in relation to paragraph 3, the word object could just as well and should just be read as meaning subject. What is the subject of the judgment you've got? And the commentators say that it is intended to mean a matter with which the proceedings, I quote, are directly concerned. This is a claim for damage to a ship arising from a breach of contract. The contract is a contract of carriage of goods, but the claim's got nothing to do with carriage of goods. And so I think that would be a claim which would be within the convention.
Right, so it's not enough just to look at what the contract is about, you also have to look at what the claim is about as well.
Absolutely, and the convention draws a distinction between preliminary questions on excluded matters and substantive matters which are not excluded. So you really do need, and because of severability in Article 15, you really might need, if you've got a complicated case involving bits of carriage and other things, and GA, which is excluded, remember, under the other exclusion, or towage, if it's emergency, it's excluded. You might have to do an exercise in saucissonnage, to be European, to split up what your claims are, to see what you can do, and then apply how they're going to deal with this in the Royal Courts of Justice in the service room, I have no idea. And then apply separating out, saying this is a claim which is not excluded, even though it looks as if it is.
All right, so that's nice and clear. Thank you. Let's throw another spanner into the works. I'm just going to pull up the slide again. Even if the claim is included, is this actually an exclusive choice of court agreement under Article 3 of the Hague Convention?
Well, I think just looking at the clause, it looks like it. I mean, in English law, I would say, well, that will have jurisdiction. I suppose it might be said, well, that might be rather permissive in its language. And should it say only the English court shall have jurisdiction? Is that the sort of exclusive wording which is required? I think the Convention deals with that under Article 3B. The Convention takes a pragmatic look at what a clause is. This clause is obviously demonstrating the intention of both parties that disputes will be sent off to the English High Court. So Article 3B says that the choice of court agreement which designates the courts of a contracting state shall be deemed to be exclusive unless the parties have expressly provided otherwise. I don't think that clause is an express provision otherwise, so there'll be a deemed jurisdiction clause. It might be different if the clause says the parties have the right to refer disputes to the English High Court, and if they do so, the English High Court has jurisdiction. That, I think, might be it's too watered down to count, but I think this would definitely count and would be deemed to be an exclusive
it's difficult.
Jurisdiction clause.
Sorry, Simon, it's difficult, isn't it, to know quite how far this deeming provision goes. It's not something I think in that this sort of context that we're particularly familiar with in English law.
No.
We tend to look at what the clause actually says rather than looking at what it says and then saying, well, actually, we're going to assume for these purposes it means something that it doesn't say.
Yeah, but I think ordinary English jurisprudence on jurisdiction clauses, leaving aside the Hague Convention, would probably say the intention of the parties behind that clause was to submit their disputes to England, not to have a facility to do so. So I think the position would overlap both from English law and Article 3B. So that's got rid of two spanners which have been thrown in the Hague Convention. It just shows how fiddly the Hague Convention is. And remember the easy days Gemma talked about earlier of Brussels 1, when it was just, you just put the paperwork through and off it went. The other option for jurisdiction would be under common law rules. And I think, as has been explained, these will overlie the Hague Convention, can still be relied upon. And then you're looking at CPR and whether you need permission or not. And you probably don't see CPR 6.33 2B. Okay,
so we think there's a case for establishing jurisdiction. Is the English court going to grant the Antisuit? Andrew, you dealt with Antisuits last week. Do you want to deal with that?
Yeah, well, as I mentioned last episode, under the Brussels Lugano regime, it was impossible for one member state to grant an Antisuit injunction to restrain proceedings in other member states, and that's the position as a result of Turner and Grovett and the Front Cornwall. And in fact, that remains the position under that regime. But we're no longer bound by that regime, and that's because we're looking at Italian proceedings commenced post-completion day in 2021, which brings us back to the common law world. So provided there's no strong reason not to do so, the English courts will in principle grant an Antisuit injunction. And I should just touch on what could be strong reasons not to grant an Antisuit injunction in this context. In addition to the more obvious candidates, such as delay in making the application or unclean hands on the part of the applicant, one might consider whether it's relevant that there are potential problems with enforcing the English judgment abroad, because that may constitute a strong reason not to grant an Antisuit injunction, particularly where the claim involves property in the foreign jurisdiction and unenforceability could render the judgment nugatory. And that's a proposition established by a case called Impala Warehousing, which I think will be in the handouts. But in our case, that argument doesn't really work because we're just talking about a claim by the owners for damages, and they would be seeking eventually to enforce a money judgment in Italy. The argument might be stronger in other words, there might be better chance of establishing a strong reason not to grant an anti-suit if the owners were seeking a remedy in respect of property in Italy, for example, delivery up, but that's not our case. And then I just thought I might briefly alight on some rather curious obiter dicta of Lord Justice Leggett and Philip Alexander and Bamberger 1996 case, where he seemed to suggest that the difficulty of enforcing an anti-suit injunction in the foreign court might be relevant to whether it should be granted. In that case, the German courts considered anti-suit injunctions to be an infringement of German sovereignty, and so they refused to serve an anti-suit injunction.
Sorry, I'm just going to interrupt. That was a little while ago, though, wasn't it?
That was in 1996, yes. And back in 96, Lord Justice Leggett said in passing that where the respondent only has assets in the country which refuses to give effect to an anti-suit injunction, that might be relevant and that might require some consideration. But yes, you're right, Gemma, that was a long time ago in the legal world. And the English courts have more recently granted anti-suit injunctions without being troubled by potential issues with enforcement abroad. And also, I mentioned during the last episodes that quite a few courts in the EU have started recognizing and indeed even issuing anti-suit injunctions. So the practical problem that Lord Justice Leggett faintly outlines now seems increasingly illusory. But just ending with this final word of warning, if you voluntarily submit to the jurisdiction of the foreign court, then that is quite likely to be a strong reason why an injunction should not be granted if you're the applicant before the English court. So it's stating the obvious, really, but that's yet another reason not to submit to the foreign court's jurisdiction.
Well, thanks, Andrew. If your head isn't hurting already, let's mix it up and let's just look at a different scenario. The one we just discussed was a claim commenced in June 2021. But what if the Italian proceedings were commenced in September 2020? How does that affect the position?
Well, again, this comes back to why timing is so important, doesn't it, Rob? I think because then you've got the Italian proceedings being commenced prior to completion date. So then under, I think it's Article 67(1) of the withdrawal agreement, the UK court should still be applying the Brussels recast regime, or if it was, it would be recast in this case. So then timing makes all the difference, and we're back under the old regime. And as I understand it, Andrew, the situation then is we don't get an anti-suit.
Oh yeah, sadly, or not for fans of EU law, we're stuck with Tinner and Grovit and the Front Comor again. And I think that means we can't really afford to chuck away all those textbooks on Brussels recast. We're going to be living with those regulations for a while, at least in relation to claims commenced in the EU prior to completion day. Because even if a claim is commenced prior to completion day and judgment isn't issued for years and years, you're still within the Brussels Lugano regime.
So we probably should have done this seminar a year ago and then could have encouraged everyone to start proceedings nice and quickly.
Yes.
Okay, all right. Well, let's assume that the Italian Charter ignores the anti-suit injunction and continues to pursue its proceedings in the Italian courts. Do we know whether or not the Italian court will take jurisdiction, even in the face of that English jurisdiction clause? Rob, what do you think?
Well, it seems to me that the recast regulations will apply because in this case, the defendant owners are domiciled within the EU. So assuming the Italian court takes jurisdiction, presumably under Article 7 that would be, because Italy's the place of delivery, then there's no discretion in the Italian court to stay the proceedings. So it will proceed.
Okay, all right, let's mix it up a bit. What if the German owner gets in first and starts the English proceedings first? What would the Italian court do then in the face of the Italian Charter's proceedings?
Well, this is one of the big changes, certainly from the UK perspective, of course, now we're outside of the regulations, because we'd be looking at Articles 33 and 34. Now, 33 gives the Italian court discretion to stay the proceedings if it involves the same cause of action as the English proceedings, and the Italian court may do so if the stay is necessary or proper is necessary for the proper administration of justice. And in considering that issue, the court should take into account the exclusive jurisdiction clause. Under Article 34, which deals with related causes of action, again, the Italian court has a discretion to stay. Of course, none of this is mandatory under Article 25, as it would have been pre-Brexit, where the UK was a member state. So this is a really important difference, obviously, from the point of view of this country. And what it means in practice, it seems to me, is that there's likely to be a race to commence proceedings in order to prevent the good old Italian torpedo. So this is an issue to which everybody really needs to be alive now, and where you issue and how quickly you take that initiative may be really quite important.
Right, so lots of incurring costs up front to start proceedings, just in case. Okay, so we're dealing with a situation here where we've got an Italian claimant and a German defendant, so both intra-EU. What's the difference, which will often be the case, where you've got a defendant from outside the EU? So let's say Singapore, for example.
Right, well, then we're back outside the realm of the Brussels regulation, Brussels Recast. Singapore is a signatory to the Hague Convention. And if we assume for the purposes of this talk that the Hague Convention applies to the contract and applies to the choice of court agreement, the position is as follows. So while the chosen court has a duty to hear the matter, the other side of the coin is the duty of the non-chosen court not to hear the matter. Under Article 6 of the Hague Convention, the Italian court should decline to adjudicate over the claim. But by contrast with the position of the court chosen, which is bound to adjudicate and has extremely limited scope to decline jurisdiction, there are 5 grounds on which the court not chosen may disregard the choice of court agreement and refuse to decline jurisdiction. So just to go through a couple of examples, one is where the parties lacked capacity to conclude the agreement, and that will be under the Hague Convention. That's for the court not chosen to decide. So here it would be a question of Italian law, whether the parties had capacity or not. And one of the other exceptions is where giving effect to the agreement would be manifestly contrary to public policy. And again, that would be the public policy of the Italian court. So an obvious case in point would be where the contract was procured by bribery. On a practical note, while Article 6 imposes a duty on the non-chosen court not to adjudicate unless the exceptions apply, in practice, I think it's likely that the owners would need to make an application to the Italian court for a suspension or dismissal of the proceedings under Article 6, because otherwise it's quite hard to see how the Italian proceedings would be stopped.
So what I'm hearing at the moment is lots of litigation going on in lots of different jurisdictions. But if the German owner starts proceedings here, is the English court going to take jurisdiction where the Italian proceedings are already underway?
Well, I think that answer to that is yes. If you've got a jurisdiction agreement which meets the Hague Convention bill, then the English court has jurisdiction, see the provisions we've been looking at, and the English court can't decline jurisdiction. Article 5 is absolutely plain that a court that has jurisdiction under paragraph 1 of Article 5, so in our case, we're assuming the English court has jurisdiction, shall not decline to exercise jurisdiction on the ground that the dispute should be decided in the court of another state. That's pretty explicit. If there's any doubt about it, turn up the explanatory report of Professor Hartley and Professor Dogauchi, which says that forum non conveniens, and it goes through what that is, lis pendems, and it goes through what that is, are excluded. There shall be no resort to either doctrine. I think that's very good. It ring fences the judgment. You don't have the discretion under other conventions, and I think it makes it much simpler. It stops all this gameplay and people starting in breach of the jurisdiction agreement and honours the jurisdiction agreement. I'm in favour of that very draconian Article 5 approach. Some people may not be.
Now, I'll be curious to see how the English Commercial Court judges cope with that, when traditionally the prospect of parallel proceedings is not something that is relished or indeed encouraged. And I wonder as well if it's going to encourage very much a race to judgment, not just a race to commence proceedings.
I think that's a very good point to make. I think it will.
But just thinking about it, because I'm thinking if I'm acting for either of these parties, there are costs mounting up rapidly here. I mean, if you're acting for the German owner tactically, is there any merit in saying, well, let's just let the Italian proceedings continue and ignore them on the basis that they're in breach of the English choice of law clause?
Well,
choice of court clause.
I would have thought that would be a very dangerous thing to do, wouldn't it? If you have assets in the EU, once the Italian court's taken jurisdiction under the Brussels regulations, there's going to be automatic recognition, as we discussed earlier. And therefore, that would be, I think, a highly imprudent course of action for them to adopt.
Well, that's the point, isn't it? Because when you're dealing at the recognition and enforcement stage within the EU, there is no going back and unpicking whether or not the original jurisdiction may have been taken contrary to something which, certainly in this jurisdiction, we think was quite powerful, such as a choice of court agreement. Okay, well, I can see we're just getting to the end of our time, so I'm going to wrap up with one final question dealing with the enforcement points that we've dealt with today. So if the Italian Charter prevails in Italy, even in the face of the choice of court agreement, and then the Italian Charter seeks to enforce against assets of the owner in the UK, can it do so? I mean, we've worked through the options of looking at potentially this might be a Brussels case depending upon when the proceedings have started. And we've looked at the question of whether or not the Hague Convention may or may not apply. We say, well, here it doesn't, because there's no choice of court agreement in favour of the Italian courts. But then what are we into? The territory of reciprocal arrangements? I mean, Rob, you touched on that earlier. Is that going to be how you would enforce, how the Italian charters would enforce here?
Potentially subject to the issue of those conventions remaining in force, which I know one of the questions that's been raised is whether they are, but subject to that, we would be looking at that route. There's a statutory instrument in relation to the relevant bilateral conventions. That would certainly be one possible route.
What about common law? Is that an alternative?
Well, it depends on whether it applies. There's no room for the common law if the Hague Convention or any of the reciprocal arrangements govern the position. But if there's any ambiguity about it, let's just assume we are looking at a common law type scenario. And the question really then becomes one of submission, because as I noted earlier, Section 32 of the Civil Jurisdiction and Judgments Act protects a party who says proceedings have been brought against them in breach of a choice of court agreement, provided they haven't submitted to the jurisdiction or made a counterclaim, for example. So really, we're going to be wondering whether we're going to be asking the owners, have you appeared to contest the merits, or have you counterclaimed in the Italian courts? If you have, then that's going to be really tricky.
But that goes back to the point we discussed earlier, which was my question as well. As the German owner, can you just let the Italian proceedings go by in order that you can say, I haven't submitted? If you know where you've got assets, and then you might find yourself in this position, you defend the Italian proceedings because it's dangerous to not protect your assets within the EU. But then you're taken to have submitted and you can't challenge enforcement here.
Yeah, it's a bit of a tightrope, really. I think the safest course, if there's such a thing, is to appear and contest the Italian court's jurisdiction, or ask the Italian court to stay proceedings on the basis that there's a choice of court agreements and all of this needs to be fought over in England. And that won't amount to submission, at least as a matter of English law. But whether that would amount to submission as a matter of Italian law, and whether the Italian court is going to go ahead and give judgment anyway, is a different matter.
Okay, well, if I can sum up, it seems to me that the new world in which we are in means that actually there is an imperative in two directions. One is to commence proceedings as quickly as possible to try and protect any choice of court agreement that you do have. And secondly, if you do find yourself in a situation where, unfortunately, these days you are going to be in a battle as to which judgment is going to be recognised and where, then you need to ideally pick a jurisdiction in which you're going to get a judgment quite quickly. because it seems to me that the judgment that comes out first is going to have an advantage. I think we might be in the back in the bad old days of a race to judgment. So it just remains for me to thank everybody for watching. The slide pack will be sent around to those of you who registered. And otherwise, I just would like to thank very much the panel, and I hope you enjoyed today's discussion.